Jewish Insights with Justin Pines on JBS is made possible in part by the clubs at Pearl River, New York, luxury rental communities for ages 55 and better, now leasing Phase 3 at the Reserve, and the B.L. Manger Foundation.
Shalom and welcome to Jewish Insights. One of the hardest transitions for me was leaving my year in Israel at yeshiva at Pardes and then arriving at Harvard for law school. I had this moment there, I remember, where after studying Talmud and Torah and all these ancient texts about how to develop the perfect world, where I had my first crim law case and they said, this case is over 30 years old. And people were like, wow, that's old. And I was like, that doesn't even count in Judaism. 30 years ago, it was like nothing. And also feeling that the American legal system was so imperfect and all this like big mess, whereas the Jewish system had these ideals that were divine. And so I felt very frustrated from that transition from Jewish law to American law. And it wasn't really until I worked at the Hartman Institute where I came across a text called the Kuzari by Rabbi Judah Halevi, which is from the 12th century, where there's this very powerful moment where the king, who's in a conversation with the rabbi there, says it's basically, I'm paraphrasing, but basically says, it's easy for you to talk about what the world could and should be. You have no power. You're not actually building a society. But if were you in power, were you building a society, then you would see how difficult it is to turn values into a legal system and a society. And I think in some ways what I've learned from that is that having the values in some ways is the easy part. Having a vision for what society should look like through a value system is the easy part, but then trying to build a society which reflects those values, that's where the challenge comes in. That's where it gets sloppy, where you have court cases and you have to write laws and those kinds of things. And so that experience gave me, first of all, a newfound appreciation for what it means to build the state of Israel in a way that reflects Jewish values, but also retroactively a newfound appreciation for America, where we do have a democratic legal system and we have checks and balances, and we're trying to create an opportunity to build a country that reflects American values. And so I look at those things differently now. I'm a little bit older, a little bit wiser. And this year, as we're approaching Independence Day, and we celebrate Independence Day, July 4th, a day that celebrates freedom, democracy, national identity, I'm very excited in this episode to turn to a voice that sits at the intersection of Jewish thought, American law, and civic responsibility. My guest, Professor Michael Avi Helfand, is a renowned legal scholar. His work sits at the intersection of law, religion, and public life. He's written and spoken extensively on religious liberty, church-state relations, and the place of Judaism in American constitutional thought. Professor Helfand is the Brenden Mann Foundation Chair in Law and Religion and co-director of the Newt-Bar Institute for Law, Religion, and Ethics at Pepperdine Caruso School of Law. He also serves as the Florence Rogatz Visiting Professor at Yale Law School. In addition to his academic roles, Professor Helfand is deeply involved in Jewish communal life. He's the senior legal advisor to the Orthodox Union's Teach Coalition. He serves on the executive board of the Beit Din of America and serves as a senior fellow at the Shalom Hartman Institute, which is how we first met. In today's conversation, we'll explore how Jewish values and legal traditions both shape and are shaped by the American experience, how recent events fit into a long and evolving legal history, and how the Jewish community can continue to contribute meaningfully to the future of American democracy. Professor Helfand, Michael, Avi, we'll decide what to call you. Welcome.
So great to be here. Thanks for having me.
All right, so first of all, how's the beach? I know you're in from Pepperdine. I'm very jealous of you that you get to live near the ocean.
Well, this is going to sound terrible. I shouldn't do this to you, but as you may know, because of the recent fires in California, actually the Pacific Coast Highway has been closed for a bit. So even though I don't normally go to the beach often because sand is not my friend, it's been very difficult to get to the beach recently. So I look forward, maybe even me, who doesn't like the beach, once they open up the Pacific Coast Highway again, I'll say a blessing and get back there. If nothing else from this interview, I've told you before that I regret all the time I spent in Harvard not ever going to see the fall foliage. Not once did I drive somewhere to see it up close. So as Counting Crows said, it's been so long since I've seen the ocean. If you have that opportunity, you got to go see it, man. You're next to the ocean. It's just right there. I grew up in Manhattan, and I think the problem for me is when I was growing up, I went, I think, to New Jersey when I was relatively young for the first time. So You're probably wondering, how long did it take you to get to New Jersey? It took me a couple of years. And I went there and I saw trees and I'm like, how do they grow when they're not surrounded by concrete? So that's kind of my demeanor when it comes to like beauty and happiness and all the other stuff. I think I just usually sit at my desk. I'm a terrible person. I know. I got it.
The Lord has an amazing sense of humor. You get at least. I hope you get a view at least out the window of the ocean sometime.
I do, but I have blackout shades.
Oh my God, you're killing me, man. You're killing me. If it was me, I'd be playing beach volleyball every day.
Come anytime.
Yeah, there you go. All right,
Okay.
I'll take you up on that. All right, so putting the beach aside for a second, let's jump in here. I think I've hinted at the fact that it's easy to be a skeptic when it comes to American law from a Jewish perspective, but I know that you've done tons of research that really points the other way, and I think the average American Jew doesn't even know about this. So can you just kind of like walk me through why Jews have cared, why Jews do care, why Jews should care about some of the key elements of the Constitution and the amendments? I know a big one is separation of church and state. Let's start with that.
So maybe I'll try to package the whole like religion, First Amendment stuff together. And I'm thinking a little bit about, maybe I'll start with kind of how I got into this. I started in a political science PhD program. And I guess after 2 years, I started to feel relatively frustrated. Like I could understand how there are these high philosophical concepts, but I couldn't figure out how they got implemented in real life. Now, people like political philosophy, go you. I also like a little bit of political philosophy, but I wanted something more concrete where kind of the philosophical principles made their way into, I'd say, daily or life in some sort of more concrete way. And I ended up switching from PhD program over to law school. And I think it really was because I thought the questions I had around multiculturalism, the role of religion in public life, I needed to see how it could be woven into how a country, a polity, citizens actually interacted and lived with each other. And, Jews I've long felt that way about the religion clauses of the First Amendment. No faith community has been more active when it comes to debates over the role of religion in public life, court cases, Supreme Court cases addressing that topic, than American Jews, which is actually kind of shocking. People have tracked this through, we'll probably chat a bit about amicus briefs, briefs filed by third parties and litigation being conducted by two other parties. No community has filed more of those than American Jews, and that's a wild thing when you think about our numbers. And I think that
just unpack that for people who don't know. I'm assuming because we're both in law school, maybe not everyone knows. This is the idea that there's a Supreme Court case, people are arguing about something, it's high stakes, and third parties will say, like, we have an opinion about what you're arguing about, and you're saying the people that show up disproportionately is the Jewish people to file these briefs.
Not even just disproportionately. You'll have A, as you say. A is fighting with B, and they have some fight over something or another, and goes all the way, can happen at any court, but like when we're talking about all the way up at the Supreme Court, there's a big spotlight there. And somebody, a fellow named Greg Ivers, actually tracked this in the 90s. Very impressive academic in his own right. And we wrote this article tracking, which faith communities have filed more the briefs in these cases implicating questions of religion in public life. And it was American Jews. It's not just that we're disproportionate to our numbers, we beat everybody else out. And I think that's because the values embodied in the First Amendment as it addresses religion, it's really been just high stakes for American Jews. There are these two clauses. You have the Establishment Clause, which is Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Those are the first 16 words of the First Amendment. This concept that Congress, and which ultimately came to be interpreted through the 14th Amendment to also apply to all government, government can't create a law that establishes religion. This is what we normally refer to, or have often referred to, as separation of church and state. And then prohibiting the free exercise thereof, meaning prohibiting the free exercise of religion. This is the concept we normally think about as religious liberty.
So like government can't endorse a religion, but also government can't stop you from doing religion.
Yes, also no. But also yes, because that's how law works.
Right.
It's like, depends.
Okay.
But yeah, both of those ideas, the government can't push a religion, and also government needs to protect religion.
Okay.
And for Jews, those ideas sometimes felt like life and death. Like the capacity of American Jews to be full-fledged American citizens here in, here, locally, on state level, federally, the idea that American Jews would be on equal footing with all others, that promise would only be protected, would only be given its full voice if we got these two constitutional ideas right, if we did have some degree of religious liberty, and if there wasn't some sort of government religion that somehow crowded us out of public spaces. And so it's not surprising we see American Jews so engaged, sometimes even the architects of constitutional doctrine, because what's at stake was really the American Jewish project. Are we as Jews going to be full-fledged citizens in the United States?
Beautiful. Okay. And then what happens?
Oh, it all goes to hell. No, just kidding. So this story starts, I'd say, probably in the 1940s. I think some people would go back further. But,
right.
I mentioned before, the first word of the First Amendment is Congress. Mm-hmm. Initially, the Bill of Rights, it applied to the federal government. Mm-hmm. It was a way to constrain the federal government. But through the 14th Amendment, interpretation of the 14th Amendment after the Civil War, and then late 19th century, early 20th century, the 14th Amendment is interpreted to incorporate the Bill of Rights, or at least portions of the Bill of Rights, against the states. Okay. And what that means is, what used to only apply to the federal government, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, that now applies to the states. The states can't engage in these types of activities that either establish religion or alternatively somehow constrain, prohibit the free exercise of religion.
So again, I'm oversimplifying, but before that, a government building in the state of New Jersey, that's a federal building that's there, can't have the 10 Commandments on the front lawn. But now a state building in the state of New Jersey also in theory cannot have the 10 Commandments. I know that's a complicated example.
Yeah, that was a complicated example. We have ongoing litigation throughout the United States over whether any of that's true. But in theory, if it were prohibited for the federal government, that would have been initially, and then 14th Amendment comes along, and now also states can't do that. And you can imagine now that you've got all various forms of government on the hook for the First Amendment, so to speak, so now litigation is going to get fast and furious. Okay. And all of a sudden in the 1940s, you start to see increasing litigation, states fighting with citizens over what it can and can't do with respect to these two principles.
Okay. So give me some examples of what were the hot cases in the 40s? What was happening back then?
Hot cases in the 40s. I think when people hear about the hot cases in the 40s, they're like, "What?" It's like watching old TV or something like that. Okay. Like, was this a thing at some point? Okay. It's like bell bottoms. They wore. Oh, I guess those might be back, but you get the idea. Mm-hmm. I would say in the 40s and 50s, the two biggest issues were government funding of religion or religious education. And the other one was prayer in public schools. Those were the two big issues. Okay. And the idea that public schools wouldn't have some amount of prayer as part of the school day, it was considered anathema. People couldn't wrap their heads around it. Right. To say that you were against prayer in public school was to say, for all intents and purposes, you're an atheist and a communist. Mm-hmm. That's really, and think about McCarthyism and everything going on, that's who you were if you didn't want prayer in public schools. And the government funding question, that was a more complicated question in some ways, really centered around a pretty significant degree of anti-Catholic animus, this idea that most of the religious schools were Catholic schools and we can't have money going to the Catholics because they like the Pope and that's a disaster. Okay. Those were the two, I'd say, big issues in the 40s and 50s that the Supreme Court was dealing with.
And did the Jews show up in those conversations already?
I would say the Jews are the architects, in many ways, of the law that applies to this area. And, if you think about it, at a time where religion was very prevalent in public life, in ways that even to the extent people feel now, we're seeing more of it, it pales in comparison to what was happening in the 40s and 50s. Right. And I think Jews saw the encroachment of religion on public life. It's a little bit of a zero-sum game. If public life is going to be religious, and it's going to be in a certain type of religion, at that point Protestant, that means there's going to be less and less space for Jews. Mm-hmm. And so Jews, led by Leo Pfeffer and the American Jewish Congress, the American Jewish Committee, the Anti-Defamation League, really pushed back on the idea of having religion in public life. They were absolute separationists, we call them. They took separation of church and state to the extreme. In no way should we be seeing religion in public life, because that's the only thing that's going to make sure that Jews are on equal footing with everybody else. If religion makes it in, it's not going to be us, and we're going to ultimately be second class.
Okay. And then what about on the funding for schools piece of it?
The funding for schools piece of it is really interesting because this idea of absolute separationism, it left no room for compromise. And so it got pushed to the nth degree there as well. When it came to school funding, the American Jewish community, and I'm thinking the big three, the American Jewish Committee, the American Jewish Congress, the Anti-Defamation League, similarly extreme. There can be no funding that goes from the state to religious institutions. There can be no funding that funds religious instruction. All of that had to similarly be struck down as unconstitutional in their view, because once you open the door, what it means is ultimately you're going to be squeezing out American Jews. That was the deep worry for the American Jewish community in the 40s and 50s. And so they pushed as well. You know, in 1947, there's a case, the first real case when it comes to after the incorporation of the First Amendment against the states, meaning it applies to the states as well. You get a case about whether or not the government can pay for busing for everybody, send busing money to families, both for kids that go to public school and that go to religious schools. And the Supreme Court 5-4 says that's okay, but the American Jewish community was against it.
Wow.
And that you get from in the 40s and the 50s, cases about textbooks, all of these cases, the American Jewish community, by and large, is saying no funding, because that means there's going to be religion in public life, and if there's religion in public life, we're going to be squeezed out.
Wow. So the best way to protect Jewish religion is to remove any support of religion from the government in general, rather than find a way to support Jewish life and Christian life at the same time.
Yeah, I think that was the dominant view. Now, as you get a little bit further along, things begin to change. So, you know, there's some people would view this as a real, secularist impulse, not in a pejorative sense, in a sense of we need the public sphere to be secular so that in the private sphere we can be deeply religious.
Do your Judaism at home?
I would say, because that I think also has a little bit sometimes negative connotations. So I'm trying to, I'm pushing back against negative connotations here as best I can. My views on this are what they are, but I think this view is not just in at home, meaning the ability for us, I think about American Jewish life. I mean, we have so much infrastructure, right? When we do our Jewish life privately, we're not just doing it in private, right? We have massive institutions, we have synagogues, we have schools, there's tons of stuff. The secularist impulse isn't that you should just kind of cower in your home and kind of, do a little bit of Judaism. It's that we should build a robust infrastructure funded by private citizens, and there should be freedom for us to be able to do that. And so it's not just in our home, but it's everywhere, just not the government.
Okay.
Is that an okay pushback?
That's great.
Okay, good.
Okay, fine. All right, so keep going. So then what?
Okay, I think this is where you get the first big schism, I would say, when it comes to church, state, and American Jewish life. You start seeing in the 60s, primarily Orthodox Jewish institutions start to push back. And they have a different view. They say, yes, we want government to be neutral when it comes to religion, but neutral is a funky word. It can mean lots of different things. And in their view, the first big issue they kind of peel off on is the funding question. And they say to themselves, no, what we really want is for government to treat religion neutrally. And that means if you're giving out money to private schools or to private institutions, just treat religion like any other private institution.
Right.
And so you start getting this big schism in the 60s, slowly but surely as Orthodox Judaism demographically starts to grow. Also at the same time, their advocacy on these points start to grow. By the time you get to the late 60s, early 70s, on this particular issue, you have a pretty big schism. Now note, that feels different. Maybe it feels different to you, I have no idea. The funding question may feel different than the should we have the 10 Commandments on the walls of a public school question. Symbolic religion you don't quite have that same schism that you have on the funding question. And maybe you can see, like, if you're thinking about it through the prism of neutrality, like, government shouldn't be have religious symbols be pushing religion in certain ways, but maybe neutrality does allow you to kind of just treat us like everybody else when it comes to funding. And these are the big fights within the American Jewish community. But on the prayer and public school stuff, the Jews really, really pushed back, and that was considered a third rail. And there were concerns, when you read the history of this stuff, there are concerns within the American Jewish community that the Christian communities, the rest of American society, for all intents and purposes, would view us as like atheists and like a threat to them, a threat to the American way of life. Like to be anti-prayer in public school was like think of like one of the most offensive things you could be now. Pick your favorite culture war issue. Mm-hmm. And that's what it was. Right. It was like ground zero for all of this. Like, they're coming for America. I say, as you know, we have this beautiful flag over here. That's what it was. It was, and Jews pushed back anyway, mm-hmm. because they thought it was important, not because they were anti-religion, but because they worried about the impact of prayer in public life, mm-hmm. On American society.
All right, so let me make sure I caught it all. So the schism you're describing, that's among the Jewish community.
That's right.
Where there are some that are saying, we don't want funding going anywhere near our schools, and there are others, probably those Orthodox are more likely to have schools, I guess, who are saying, wait a minute, right. Like the private school down the block from me is getting free busing or free food for the kids or whatever it is. Not free, paid for by the government. Why can't we have that too? Just be religion blind instead of being, it's not pro-religion.
That's exactly right. So it's, it's hard. Sometimes people like describe when it comes to separation of church and state in these early years, like what was the American Jewish view? And you have kind of the consensus, and then you have orthodoxy on the side with respect to the funding question, but it wasn't like an all or nothing thing. Like, you have to look at your different issues and see kind of how it comes out. Another good example, we were just chatting about this, this is the Sunday closing laws issue. Mm-hmm. And this maybe will give you a really good feel for how different kinds of values animated how Jews thought about these questions.
Great. So just say a word of what that is. I know I live in Bergen County. So
you live in Bergen County. This is it's a cosmic joke.
Yeah.
That the last blue law, or Sunday closing law, meaning some subset of commerce that is prohibited on Sunday. Back in the day, almost every state had these things. And now it's just Bergen County where all the Jews live, which is hilarious.
Just to clarify, stores were closed so people could go to church. It was Shabbos.
So I love that you say that, and I'm not saying you're wrong, but the Supreme Court explicitly says you're wrong.
Okay.
Now,
what do they know? Okay.
No. By the way, you may be right. No, I'm completely with you on that. But hopefully you see in the way you characterize it, you can already see the Supreme Court, when it talks about this, they're like, what do you mean? This is Family Day.
It's Family Day.
And they're like, what else? What other day would we pick as Family Day? The day that most people want to be with their families. Right. This has nothing to do with religion.
It's about football.
They say things like, you joke, by the way. Current Sunday closing law, my wife's from Memphis, Tennessee. So we lived in Tennessee for a year while I was clerking for a judge. And their Sunday closing law is until noon. And you say, why is it until noon? Well, I don't know. I haven't gone through the legislative history, but call me crazy for saying, well, before noon you're in church, but after noon you have football.
Right.
So we need to figure out how to split the baby over here. You need to make sure no alcohol in church, yes alcohol for football, and I guess those are the two halves of American religion.
Wow.
Something along those lines. Okay, you can see how you build these.
Sure.
Okay, all these are great. So nowadays all we have is Bergen County. Back then, it's everywhere. And this was, again, like a big culture war issue. To be against Sunday closing laws, like you were saying, like America sucks. That's what you were saying.
Again. And Bergen County is the only place left?
All Bergen County.
No way.
Place. Yeah.
Amazing.
Well, no, there are other little ones, but Bergen County is the only one that has it across the board.
Right. Which has a disproportionate number of Jews who can't shop on Saturday.
Yeah, but they love it because they don't want all us New Yorkers from Manhattan showing up in New Jersey and bothering them. Okay, fine. So, so go back to the 1960s where Jews start challenging these Sunday closing laws. Now,
because?
Okay, good.
Good.
So let's talk about the facts, and then let's try to figure out why backwards, I think. So you have this one case that comes up, Brownfeld v. Brown. Comes before the Supreme Court in 1961. And what you have in this case is plaintiffs who are Orthodox Jewish merchants. And they say this Sunday closing law is unconstitutional. Okay. And why do they think it's unconstitutional? Here's their beef. Our competitors are open 6 days a week. We are Orthodox Jews. We've decided that we're not going to work on Saturday, and you're forcing us to be closed on Sunday. We're open 5 days a week. We're going to lose to our competitors. There is an indirect burden on our religion because of this Sunday closing law. Okay, that's their issue. It's an economic issue. Okay. A number of Orthodox Jewish organizations file an amicus brief in this case. Again, a third party. They're not in the case, but they have views about the case.
Yeah.
And they express their views about the case. And here's what they say the problem is. They say the problem with the law is that it comes from religion. It's the imposition of a particular religious practice or religious worldview on others, and that's the problem. Okay, so let's think about this for a second. If you're the merchant, what do you want the state to do? Your problem is an economic problem. So the way to solve the economic problem is pretty straightforward. You just tell everybody, if you're closed on a different day, you get an exception to the Sunday closing law. Meaning keep the law on the books.
Yeah.
You do you. Just give me an exception.
Yeah.
Solve my economic problem. Everything's fine. If your beef is, this is a religious law that's imposing on others, the exception doesn't help you because the problem is the existence or the manifestation of, let's call it coercive religion in public life. And the only way to solve that problem is to take the law down completely.
Right.
So you can even see in this case the way in which two very different expectations of how America would make space for Jews in the public sphere, each of these different views press for a different shape of the law. I just want an exception. To me, the American dream is economic opportunity. I should be on equal footing. That's what it means to be a full-fledged citizen, that because of my religious commitments, I'm not losing out on the capacity to build my business, build my family, have opportunity. And so we can solve that problem. You keep your law, I get an exception, and this is the American dream. Or, my American dream is undermined so long as there are laws on the books that represent some majoritarian religious worldview.
Right.
And you can give me all the economic opportunity you want, but the mere existence of that law is a threat. And it can spread to other areas of life. And that's undermining me as a full-fledged American citizen. These are just two very different views of what America owes the Jews in some way, and other faith communities, what America owes its citizens. And you see these splits growing and growing in the 60s. Orthodox Jews increasingly, neutrality, give us exceptions, this is what we're looking for. And you see this, on the other hand, more progressive Jewish organizations, the big three that I mentioned, the two AJCs and the ADL, looking for something different, pressing for absolute separation, which demanded very, very different things when it came to public life.
Beautiful. And coming to me right now is a third option, which would be, I have like Ari Lam, a previous guest in my head, talking about Judeo-Christian values being the backbone of America. A third option could be not that this is the exception, but that every business is required to be closed one day a week. Pick whatever day you want, because there's a value that goes through Judeo-Christian values that we should cease from working one day a week, and that it should be that. So it has to be Sunday as the default. It should be there's some way, and that allows workers to have a day off or things like that.
So on the back end, states start pulling out these Sunday closing laws. So then what do they do about employees who say,
I want to go to church or watch football?
or whatever it may be. This can be, you see how this becomes a problem. States try to start tinkering with this. And one of the issues that the court brings up in striking down a Connecticut law that says you can't do anything to, an employee gets to pick his Sabbath, much along the lines that you're describing, gets to pick a Sabbath and you can't do anything to him. As a result, the Supreme Court says that the problem there is that the way in which it privileges, it says a lot of things in a very short opinion that's a little bit, people puzzle over this one, Estate of Thornton v. Caldor. And one of the things the court says is you're privileging a particular religious practice, meaning that the idea that the law would have more to say about Sabbath observance than anything else may itself be a problem. So one wonders if like that model of, you know, here's this thing and everyone pick your thing, it obviously, as all kind of, I'd say, pluralist impulses when it comes to religion and public life, the problem they have is, you know, at the boundaries, you're still excluding in some way or another. Pluralism is invariably imperfect. And I think that's always been the challenge for the pluralist. We want, you know, let 1,000 flowers bloom, but like, wait, your law's only about Sabbath observance. Here's a list of religions that have nothing to say about that topic, so what do they do?
Right.
And that's a challenge. I think that's always been a challenge.
How else does this evolve over time?
So what you get is increasingly 70s, 80s, the Supreme Court is pushing hard on separation of church and state. It has this pretty strong impulse that what that means is public spaces need to be secular. When you look at the Lemon Test, the first prong, the first factor, well, not factor, prong is probably right, of the Lemon Test is that the government legislation, regulation, practices, they need to have a secular purpose. So you can see how built into kind of the constitutional law at that time was this idea that we need to keep religion out of public spaces. And, you know, starting in the 80s, the court starts to shift a little bit. I'd say towards a more pluralist model. You used this word early on, the word endorsement. And then the court starts to shift. Justice Sandra Day O'Connor is really the architect of the law here, saying, no, maybe what we should be thinking about is a little different. Maybe it's not kind of being secular. The government just shouldn't endorse one religion, because when it does that, it makes everybody else feel like second-class citizens. So maybe we should say government can do religious stuff, that's fine, but not to the point where you start feeling like you're crowding other people out. Now, I've always felt like some appeal in this principle. The problem is implementing it is very difficult, because you start staring at stuff and you're like, I don't know. Do I feel like a second-class citizen? Is this just like really nice? Christmas displays were huge here. 84, we get a case, Lynch v. Donnelly. It's got like a wishing well and a nativity scene and like reindeer floating all over the place. And you're like, how do you feel when you stare at this thing? And some people are like, this is wildly offensive to me. It's on public property. This is craziness. How can you do that? Some people are like, oh, that's cute. Love it. You know, jingle bell, right? Yeah, who cares? You know, that's great. And so line drawing around endorsement became very difficult. I think from the Jewish community's perspective, the most interesting case is a case, County of Allegheny v. ACLU, 1989. There, the city of Pittsburgh is really dealing with two religious displays on government property. They've got a nativity scene in the courthouse. The court strikes that down. And then they've got this amazing scene. They've got a massive Christmas tree. I want to say it's 40 feet, 60 feet, something very, very large.
Okay.
And then, this I remember, an 18-foot menorah, because obviously they were going for chai with the size of the menorah, okay? And the question is this okay? And how should Jews feel about the fact, like, awesome, like our menorah made it in, or should you be like, oh, we shouldn't have religion here? And the court like splits all over the place. You've got different factions. You don't even really have a majority opinion to sort this out. At one point you find the Supreme Court is talking about, I don't know, maybe instead of an 18-foot menorah, they should have had an 18-foot dreidel. I mean, the stuff reads kind of wacky. And I think Jewish groups had very, very different views. You know, some of the more conservative, lowercase c, Jewish groups, their view of this was like, guys, the late 80s, like having a little bit of religion, like this is a good thing. Like we really need more of that in public life. And again, the kind of legacy Jewish institutions are like, this is a terrible idea, guys. Like we need to keep it all out. Even if it's our menorah, we need to keep it out. And the 80s are a bit of a mess on this front because it's hard to know what rule to use. Should it be secular? Should it be pluralist? Should we care about whether it endorses? Should we care about how we feel about endorsement? These are hard ways to draw lines to have consistent Supreme Court decisions. And this mess has really, in some ways, carried us through until kind of the last decade. You know, the present court's conservative turn. Just recently in the praying football coach case, I don't know if you all remember that. That's the coach that was praying at the 50-yard line after games, and it seems like he gets fired, or he doesn't get renewed, or he quits before "you can't fire me, I quit," or something along those lines. And he says, "It's my religious liberty right to do this," and the school says, "We don't want to look like we're endorsing religion," and the Supreme Court says, "We're getting rid of all of this. Forget about endorsing, forget about secularism. We're going to go back to like what history has to tell us about separation of church and state." And we're in a bit of a holding pattern right now. It's not clear what the new rules are going to look like. And I think that raises some pretty serious concerns for the American Jewish community. I'd say the big thing is everybody agrees that what this principle now means is you can't force people to do religious stuff. I can't run a public school and have kids come in and say, "Everyone's praying right now." I can't force them to pray, but like anything else, is that really it? Just when I force you, can I just put up religious displays everywhere and say, "I'm not forcing you to do anything"? I think there are real questions right now about how far government can go. And, you know, I've been surprised that some of the legacy Jewish institutions have not been pushing on this as much as they used to. But we've got active litigation everywhere. Louisiana's got 10 Commandments in public schools, so does Arkansas. Texas has chaplains in public schools. There are a lot of new regulations, statutes, policies where religion is starting to move back into the public sphere in a way that used to deeply concern American Jews because of what it meant for their ability to fully participate. And I don't think we know what the ground rules are, and this is, I'd say, going to be the big issue for the next 5-10 years.
And I wonder also if maybe there's an element of what seems high stakes for the average Jew these days is much more related to politics than religion. And that like someone coming in from a different political party and staking something in the school would be much more offensive to them than someone leading a Christian prayer, for example.
I'll tell you, one of the interesting things is the court just heard this case. One of the big cases now is Mahmoud v. Taylor. This is a case about LGBTQ inclusive books that are being read in Montgomery County classrooms. And they're being read to, I think, relatively young kids. I think starting age 4, maybe age 5. And, one of the things, you see, obviously so much of our fights are about public education, and how we get to, inculcate values in our kids. And that case, when you put it up against like Louisiana and the 10 Commandments right now, they start to look kind of similar. Like a lot of this is about the different ways in which we create public spaces, public education, where it's the right amount of government educating and also the right amount of parents being able to control certain things about what their kids do and don't learn. And, I'm not sure there's just such an easy like religion versus politics line over here. They start to get, and increasingly, get blurred on this point. But I would say I think this is where our next decade of fights are headed.
All right, last question on this and then we'll move on. Same-sex marriage. I feel like this was another area that, like, at least when I was growing up, that was like the hot topic. It was like the baker who didn't want to make the wedding cake for the same-sex couple. What's
the deal?
Well, how did the Jewish community navigate that challenge, and is that continuing to this day, or that's kind of behind us at this point?
Yeah, I mean, the story there is, it's running in parallel to the story I just told, and in some ways, maybe even in the Sunday closing law case, you can see some of the overlap. But there, by and large, the American Jewish community was together on questions of religious liberty. I want to try to kind of differentiate that. There I'm talking about cases where you have some sort of law or regulation that may require or put a cost on people who are religious. And, in a series of cases, the Supreme Court in the 60s, 70s again, was very protective of religious liberty, and the American Jewish community was pretty much in one voice, all behind that.
Right.
Now the cases there were like, they didn't feel like culture war cases. They're like about unemployment benefits. Like this woman Adele Sherbert in the early '60s says, I can't work on my Sabbath, and therefore Seventh-day Adventist, I can't work on my Sabbath. And her employer says, then you're fired. And she goes to collect unemployment. They say, you don't get unemployment. You're fired for, good cause. You didn't show up to work. And she's like, no, that's my religion. You're like, well, how should I look at this thing? And she wins her case. They say, no, you can't do that. You can't say that she doesn't get her unemployment benefits for not showing up on the Sabbath, on her Sabbath. And the American Jewish community is behind her. And then when the Amish say, we are pulling our kids out of school after 8th grade because we think keeping them in the public school is a threat to our religion, the American Jewish community, again, is all behind the Amish. It's not until like the 80s that you start to see some splintering. And a lot of the splintering is like, okay, we got it. You want to opt out of public education, fine. You want unemployment benefits, fine. Those don't feel, they're very important, but they don't feel like fraught in like the cultural sense. 80s when Bob Jones University says, if there's interracial dating, we're going to expel you. And the IRS comes in and says, we're taking away your tax-exempt status. Taking away tax-exempt status, I guess, is a hot topic these days. This is from the 1980s, so the government pulls Bob Jones University's tax-exempt status. And now the Jewish community isn't so sure where it is on this one. And that's probably the beginnings of this kind of the Jewish community not being 100% sure how it should deal with cases. One way to think about these cases is you have minorities on each side of the ledger.
Right.
So you've got Bob Jones University that has a particular worldview, theologically based, and you can just easily see how, like, today it's Bob Jones University, but next it could be it could be a Jewish university that has a particular practice that runs afoul of something else.
Yeshiva University.
Who knows what it could be. In any event, so you can see how there you have a wide range of the National Jewish Commission on Law and Public Affairs gathering together a host of, I'd say, lowercase c conservative Jewish groups says, we think this policy is bad, but the whole point here is religious liberty is supposed to protect minority religions who do things that are not in keeping with what the majority does. If it was in keeping with what the majority was doing, they wouldn't need the protection. They'd just be protected by plain old democracy. Fine, great. And then you have other groups saying, what do you mean, excluding people from higher education? Like, that's like what we Jews are all about. We're all about trying to make places for people in higher education. And of course the IRS should come in and take away their tax-exempt status if they're excluding, if they're discriminating in higher education. So you can see how these cases really touch a nerve. They touch a nerve because Jews, I think, in many ways can see themselves on both sides of these cases. And as you alluded to, like as you get into the 21st century, questions around same-sex marriage, reproductive rights, all of these kinds of cases start pulling at these same issues where, on the one hand, religious liberty is meant to protect unpopular religious commitments. That's literally its purpose. And on the other hand, you have these other you have anti-discrimination law, which is, Jews faced, you go back to the 50s and 60s when we enacted many of the federal anti-discrimination laws. I mean, Jews were the greatest beneficiaries of them. And so I think these cases become increasingly hard for the American Jewish community to navigate, and you do start to see a split in the early 2000s. Early 90s, late 90s, really, the American Jewish community is like, how can we bolster through legislation, the Religious Freedom Restoration Act, increase religious liberty? And then slowly but surely, 2000s, 2010s, the Jewish community just isn't so sure when and how it wants to invoke religious liberty, because an extreme view seems to run into other really important government interests. And then you worry. If you say, well, this is an important thing, like, can you trump religious liberty all the time? I think it has become, as a result, a very fraught question for American Jews.
Got it. Okay, you mentioned anti-discrimination laws. Talk to me a little bit around, this certainly feels like a hot topic right now, anti-discrimination and free speech and those elements of, we have people shouting things that feel like they are hateful speech, to put it mildly, towards Jewish people, saying it on college campuses, walking through college campuses and saying it on the street. And we have this balance between trying to give people the right to free speech, but also it feels like there's all these cases where if they were saying about any other minority group, it would be quashed in a minute.
Yeah.
What's happening there, and what do you make of it?
So one thing I'd say, as best I can tell, this issue is starting to wane a bit. In the early days after October 7th, I felt like I was getting a lot of phone calls and sending people to this person and that person to try to address these questions. And in many ways, it feels like we're seeing less of it. So that's one trend I think worth noting. I think, here what we're dealing with, again, as you say, is federal anti-discrimination law. So what's the puzzle over here? In theory, private institutions, they're not regulated by the First Amendment. They're not regulated by anything, right? We just talked about the first word of the First Amendment is Congress, which got interpreted as government. You and I can tell you to stop talking anytime I want, and then you tell me to leave the show, and that's kind of how it would go. But we do have federal anti-discrimination law, really the result of the 60s and then early 70s, which prohibits private institutions from discriminating in a variety of ways. So, you got lots of things. You got Title II that says businesses open to the public can't discriminate in certain ways. We've got Title VII that says private employers can't discriminate in hiring and firing. Title IX, this is all of the 1964 Civil Rights Act, although Title IX is from 1972. It's fine, it's the same name. Okay, good. Title IX says educational institutions can't discriminate on the basis of sex. All of these are in different spheres of life. We tell private institutions, we know normally you're allowed to do whatever you want, but we have now federal legislation that constrains your ability to discriminate. And again, this is like the stuff that we benefited from. The hotels in the 50s that said no Jews, they can't do that. And the jobs that said no Jews, Title VII says you can't do that. So we're massive beneficiaries as American Jews of anti-discrimination law. And then you have Title VI. There wasn't a ton of litigation over Title VI, 30, 40 years ago. But now there's a lot. And Title VI says if you receive government funding, you can't discriminate on the basis of race, color, or national origin. So this is Title VI is where all the action really has been on these questions. Yeah, free speech, we don't have to give it to you. Universities like to abide by private universities like to abide by free speech principles, but they have no obligations when it comes to the First Amendment. Okay, so now what's happening over here? Are they discriminating on the basis of race, color, or national origin? So step one, people are like, wait a minute, Jews, we're not race, we're not color, we're not national origin. Although when you say national origin, people start to wonder. And then people start to ask questions. And actually, the Department of Education, across 4 administrations over the past 20 years, has said, no, anti-Semitism qualifies as discrimination on the basis of shared ancestry or ethnic characteristics. And that counts. And because it counts on Title VI. And if you're an institution that receives government funding, which every university is, well, not every, almost every university is, then you can't discriminate on the basis of race, color, national origin. But you might say to me, but Michael, or but Avi, depending on what you wanted to call me, you might say to me, they're not discriminating. They're just sitting in their offices, typing, and, third parties, students, outsiders, employees are doing all this other stuff. This is where the rubber meets the road. Title VI also has been interpreted to mean you can't be deliberately indifferent. So you can't say, I don't see any discrimination going on, everything's great over here, and you've got kids Jewish students locked in the Cooper Union library and they can't get out and get an education. So these cases, the free speech piece is kind of secondary because these institutions by and large have pretty significant freedom when it comes to free speech doctrine. The question is, are they engaged in the kind of behavior that's so offensive, as the courts say? It's objectively offensive, it's severe, it's pervasive, that it starts to look like they're being deliberately indifferent to the fact that Jews are being excluded from you have pervasive anti-Semitism that's preventing students from getting an education. And so this is kind of the big puzzle, what to do about these things. And as you said, I think one of the great challenges is there certainly feels like, given the way things have gone over the past couple of years, it has been the case that in other instances on college campuses, when people have felt like they have been, they subjectively feel like what others have said have caused them harm, that universities have stepped in. And the challenge here is that we have not seen universities step in quite in the same way, or at least the perception is that they haven't stepped in quite the same way as they did in other instances. And so you start seeing, at least certainly the advocates will tell you, differential in treatment when it comes to these issues. I'd say that's kind of like the big ticket item over here. You know, what makes a lot of Jews feel like they're second class with regard to this topic is that they don't see themselves receiving the same protections that others felt. Not just what's being said to them, but that the reaction isn't the same as it's been for others. And I think that's kind of one of the big puzzles to try to work around on this issue.
Got it. Okay, last question. I wanted to speak about it more, but I know that you're involved with Teach. Say a little bit just kind of what the thesis is there. We've come in some ways full circle. We talked about at the beginning, keep money, federal funding away from Jewish private schools, and then we've had this development where we're trying to find ways for federal money to come towards Jewish private schools. Say a little bit about that.
So I'm very passionate about the work I get to do with Teach now. I got pulled in by a fellow named Maury Litwack, who recently actually stepped down and opened a new organization called Jewish Voters Unite. They actually just recently announced a new head of the Teach Coalition, Sidney Altfield. And the organization is committed to equal funding, the equitable funding, accessibility to Jewish education. And the piece of it that I'm very engaged in really goes back to the 1960s. And I talked about that schism early on, about how we view funding. So Orthodox Jewish advocacy in this space has always been very consistently, since the early 1960s, maybe mid-1960s, we can fight between 1961 and 1965, has thought that part of being an American citizen is that when it comes to funding, we should receive that funding on neutral and equal basis. So back in the day, the Supreme Court would say, if you provide funding in a variety of ways, it is prohibited. And in a series of decisions over the last, I'd say, 10 years or so, the Supreme Court has said not only is it permissible to treat religion equally, to say, oh, you're giving historic preservation grants to old buildings, give them to houses of worship as well. But now it's said to exclude religion, that's discriminatory, and that violates the principles of religious liberty. Because you're religious, you're losing money. And we've been doing a lot of work, litigation, advocacy, on this particular point. There are hundreds of laws around the United States. We just launched a website called religiousnequality.net that identifies laws in every single state that still do this, that say money for everybody except for religious groups.
Give me one example.
Want my favorite?
Sure.
In Massachusetts,
Yes.
the armed forces can, if they have food that's going to spoil, they can give it to they can give it to charities to give out to people who are hungry, unless those charities are religious, and then the implication, I guess, is that the food must spoil. So I think these things are bad. I think they're bad as a matter of policy, but I think more deeply what bothers me about these laws is I feel like it's undermining of my American citizenship, that it says that benefits are available to all unless you're religious. And I think that's a problem. And at least you can view it a different way, right? The separationists will tell you, no, you're misunderstanding the idea. We needed to keep it out so that we can build that robust infrastructure privately, not in a cowering way. It's in a bold way we can do it, but we don't want government involved, tipping the scales by using its influence, its resources. But that's not my view. That's not kind of how I see the world. I see the world as if I'm engaged in activities that everybody else gets the support from the government because the government thinks it's important, to exclude me because I'm part of a religious institution or because of my religious activities means that I'm less than when it comes to my American citizenship. So I always say, even if there weren't a single dollar at stake in any of these cases, it would be very important to fight for them because I think it's an integral part of being a full-fledged American citizen. You know, we recently had this litigation out in, I'll never forget this, out in California over special needs education. You can become a state-certified special needs school in California. There are a variety of requirements, and if you do that, when the public schools can't provide sufficient resources, education to a special needs child, they can refer them to a private school, and the funding follows the child. In California, you can be a special needs school as long as you file all these requirements. The one thing you can't be is a religious school. If you're a religious school, you can't become state certified. And I will never, ever forget a meeting I had when I knew very little about this with, I'd say, maybe 20, 25 special needs families, explaining like the kinds of challenges and choices it made them engage in. And it all felt so deeply wrong that families with wonderful, wonderful children who have a special set of needs that the government is obligated to provide for, and feeling like their choices were constrained in ways that they weren't constrained for others because of their religious commitments, it felt like just the most extraordinary undermining of their standing as American citizens. I can like still picture the meeting, and I kind of promised to myself at that point, like, this would be something that it ought not be. Mm-hmm. And again, others have a different worldview on this, and I think it's coherent, and it's, it in many ways protected Jews from a wide range of things for decades and was vitally important. But if you ask me right now, the idea that we'll let these kinds of laws persist is a failure on our part. It's a failure to protect Jews who need protecting in a variety of ways, to get them access to what they deserve as American citizens. And I suspect this will be, if you're kind of looking at the big ticket issues over the next 10 years when it comes to church and state, I mentioned kind of religious symbols, displays, prayer in public schools. This funding question, will states and localities follow through on what the Supreme Court demands when it comes to neutrality in funding? I think this is going to be one of the big issues over the next 10 years.
Wow, fascinating. Fascinating also, especially considering where we started this conversation and how the Jewish voice has evolved on this. It's so interesting. It's a stark reminder of just the greatness and also evolution of America and the role that Jews need to play in terms of, evolving our needs and our goals and how we think about some of these questions that come up. We're out of time, but I just want to say, Professor Helfand, it's a pleasure and an honor. I wish you a happy 4th of July and Independence Day, and may we see all these great things you're discussing come to fruition in the coming years.
Thanks so much for having me.
Okay.
הנה מה טוב ומנועים שווה שכיר